Thank you. What I'd like to talk about is some of the ways in which First Amendment doctrine provides useful guidance in understanding the Second Amendment. In my article, I provide some justification for why the First Amendment should be used, but I'd like to go right to how it can and should be used. One can make philosophical or theoretical arguments about whether the First Amendment should be used to interpret the Second Amendment. But one thing we know for sure is that courts are using it. The two leading cases from the circuit courts that post-Heller both relied significantly on the Second Amendment. Zell versus Chicago, striking down Chicago's ban on firing ranges in the city, and the Heller 2 case that Steve Holbrook talked about in the D.C. circuit on, he's invisible now. He got his invisibility cloak out, discussing the, upholding D.C.'s ban on certain firearms and magazines. And you can argue about how well those cases applied the First Amendment, and I think that the Heller 2 court didn't do so correctly, but they did cite lots of First Amendment cases. And it's sort of inevitable that courts will be doing that. The First and Second Amendments are both substantive individual rights, as opposed to much of what's in Amendments 4 through 8, which are more in the procedural nature. That's about the criminal justice process and when you can be searched and ultimately how much you can be punished, whereas the First and Second Amendments are about a right to engage in particular conduct and activities. And so with the First Amendment having, since the 30s, developed a very rich body of case law, it is only natural that courts can and do look to the First Amendment by analogies. And of course the analogical reasoning, as everybody learned after just the first few weeks of law school, is one of the core tools of legal analysis. So for one thing that the First and Second Amendment have in common analytically is they are not limited to the core, their cores, although that battle has been basically resolved in the First Amendment and is still going on in the Second Amendment. As of 1965, you could, in a respectable law school, say the First Amendment only protects political speech. And you would have been even more respectable if you'd said that in 1950. Today, that would be plainly wrong. There is no doubt that the First Amendment doctrine as it has developed protects things that are not in any way involved in political speech and that it don't really communicate anything you could reduce into words. An abstract painting is unquestionably protected by the First Amendment today. That wouldn't have been so clear in 1938. Likewise, in the Second Amendment, the courts in Heller and McDonald suggested that it is all law, and when you get a suggestion from the Supreme Court, it should be taken pretty seriously, that the Second Amendment protects all lawful uses of firearms, and that the right of self-defense in the home is the core of the Second Amendment. Some courts and commentators have incorrectly claimed that self-defense in the home is the only thing the Second Amendment protects, which is wrong. That's mistaking the apex of the triangle for the entire triangle. It's the most important part of the Second Amendment according to the Heller and McDonald cases, but it's certainly not the only part. And so hunting, for example, is a Second Amendment activity. But as with the First Amendment, the further you get from the core, the more leeway there is for permissible regulation. And hunting necessarily has to be regulated for species management in a way that that self-defense in the home cannot be. Secondly, the First and Second Amendments both have synecdoches in them. And synecdoche is a really fun word to know and use. What it means is when you use a part to stand for the whole. So instead of referring to my automobile, I call it my wheels. Although really if it were just the wheels, it would be much less useful for transportation. The First Amendment has, one of the synecdoches in the First Amendment is the press. The freedom of the press was, at one time, some people suggested, it was only about things you can do with a printing press. So does it apply to newspapers and magazines and books? Yes, because strange as it may seem to believe now, for most of American history, those things could only be produced with a printing press. But and there was a lot of First Amendment scholarship and discussion about things like the radio and television, which are certainly not presses. So are they? What is the press? Does the press mean journalists, or does it certainly does mean, among other things, the physical object of a printing press? And today it has, the resolution of that radio and television discussion in favor of them being protected made it uncontroversial and easy for people to see that weblogs and publications that are published in purely electronic form are obviously protected. The Second Amendment, one of the Second Amendment synecdoches is the word arms. Yes, it definitely applies to arms of the type suggested in Heller as being what's protected, not nuclear aircraft carriers or machine guns, and probably, well, case hasn't been litigated because there would be no point. Poison gas doesn't count either, or anthrax spores, but it doesn't. It certainly includes weapons, firearms being one type of them, but air guns, which are guns but not firearms, would be included as straightforwardly as arms, and so, as I've argued in a Michigan article, knives. But in addition, arms also includes defensive devices. That would be the Kevlar vest today, or it might have been something made of leather or metal in an older time. And this is actually consistent with the first dictionary of the American English language by Noah Webster in 1828, where he defined the word arms to include, quote, armor for defense and protection of the body. And similarly, arms includes alarms. The word root, where we have the word A-L-A-R-M, comes from the Italian A-L-L apostrophe A-R-M-E, literally meaning to the arms. An alarm is what tells you you need to go get your weapons and your defensive armor of whatever type. And so I suggest that the Second Amendment right to arms, including the right to alarms, means that it would be unconstitutional for a jurisdiction to outlaw burglar alarms. Another principle is that the First and Second Amendments also contain rights which are necessarily implicit but are not expressly enumerated. If you've taken the First Amendment class, you know this is absolutely true, because you can have many pages in your First Amendment textbook on the right of association. The word association never appears anywhere in the First Amendment, but starting with NAACP versus Alabama, the Supreme Court, in my view, correctly ruled that the exercise of other First Amendment rights to petition government, to assemble, freedom of speech, and even of the press, if an organization publishes things, necessarily means that there must be a right of association so that people can do that. And then in this NAACP versus Alabama, this association had certain privacy rights against the state government getting lists of its members, which were at high risk of ending up in the hands of the Ku Klux Klan, which was often tolerated by state and local government at that time. And since then, the right of expressive association has been upheld and extended in many cases. So it is not just about the most sort of purely political situations, such as the NAACP was engaging in, but about the right of a group to have a parade and include the members that it wants in the parade and not other members. Similarly, the Second Amendment necessarily includes the right of self-defense as a right in itself. we know that from Heller that the Second Amendment's core is the right of self-defense in the home. And it wasn't only the handgun ban which Heller struck down. There was a separate provision in D.C. law which said if you do own a legal gun in your home, which could either be a grandfathered handgun that you possessed before 1976, or it could be a rifle or shotgun you had lawfully acquired after that and registered in D.C. law, it had to be either locked up or disassembled at all times. And there was no exception for, well, what if someone's breaking in and trying to kill my family? Can I unlock it then? And the answer was no. The D.C. city government vigorously defended what I just said as at the district court level when the Heller case was beginning. The D.C. Municipal Code differentiated a gun that was lawfully owned in a place of business for which you could use it for self-defense, but you were not allowed to use a gun for self-defense in the home. And the Supreme Court separately struck that down as a Second Amendment violation. So I think the right of self-defense means not only you have a right to use arms for self-defense, you have a right to use tools for self-defense, such as guns and knives. I think it includes the right of self-defense in general. Imagine a statute in which the legislature says, okay, we got to obey Heller, so it is legal to use a gun for self-defense. And we read Kopel's article in the Michigan Journal of Law Reform, and so you can also use a knife for self-defense. But you cannot use your body for self-defense. Somebody's coming up to you and attacking you. You can't poke him in the eye with your thumb or knee him in the appropriate place, use your foot to step on their instep and break their a bone in their foot, thus ending the attack. It's illegal to use your body for lawful self-defense. That would be, I suggest, a violation of the Second Amendment. And after all, the reason we call them arms is because you use them with your four limbs. These are tools that are integrated with the use of your physical arms themselves. And it seems that, again, the word root leads us to thinking that you can use your hands and fists for self-defense. And this actually is an issue not so much in the hypothetical of the Tennessee legislature outlawing the use of punching someone in self-defense in general, but it actually is a significant and large problem at public schools where self-defense has been outlawed, and the zero tolerance, zero common sense policies about violence at schools make no distinction between the violent aggressor and the person defending herself against the violent aggressor. The use of violence is punished equally on both sides, and that is irrational, immoral, and, I suggest, unconstitutional. Let me suggest a couple constitutional detailed First Amendment doctrines that are especially useful in a Second Amendment context. First of all, in the free exercise of religion cases, the court's current position is that if a law is neutral in the way it is written, then it is probably not going to be a free exercise violation. So the fact that it is illegal to walk around naked in general down Cumberland Avenue does not violate the First Amendment, even if someone has a very sincere belief in nudism and naturalism as a religion. And if there in fact were an organized religion that promoted that, the anti-nudity ordinance would be still lawful. But an exception to that happens when, even if you have a neutral ordinance on its face, it is written with malicious intent for the purpose of harming a religion. The classic case of this from a few years ago is Church of Lukumi Babalu I, Inc. versus City of Hialeah, Florida. And there, in order to suppress the animal sacrifice practices of the Santeria religion, which is sort of a modernized version of religion from Haiti and ultimately in some ways going back to Africa. The City Council enacted a ordinance which outlawed killing animals in town in general, and then had all kinds of exceptions to it, but the exceptions were careful not to include what the animal sacrifices in Santeria religion. And the Supreme Court struck this down because they could see the animus, that the anti-religious animus that lay behind the ordinance. Well, this is not a situation where, if a gun control law passes Congress, you will have situations where there is a minority of legislators who are hate motivated. They hate the Second Amendment, they hate gun owners, and anything that you can do to harm them, these legislators will vote for, and some of them are not shy about expressing their point of view. That doesn't mean that the legislation is necessarily unconstitutional, because when you have something being passed by a state legislator with 70 people voting in favor of it between the two chambers, or Congress with over 300 people voting for it between the two chambers, you can't say something becomes unconstitutional just because there's a few fringe nuts who happen to vote for it. On the other hand, when the animus comes from the sponsor of the legislation, that tells you something different when it comes from the leadership of the legislation, and I suggest that is one reason why, properly understood, New York's so-called SAFE Act, recently pushed through the legislature by Governor Cuomo, is unconstitutional, because Governor Cuomo, in his speech, saying why he was having an emergency session of the legislature, which means they would have to vote on the bill before they could read what was in it, said nobody needs more than 7 rounds to go deer hunting, which is very true. However, deer hunting is not may be part of the Second Amendment, but it is not the core. And when he says, I'm outlawing this because nobody needs it for deer hunting, he in essence is saying, I don't care about people's right to exercise their core Second Amendment right of lawful self-defense. The principle of void for vagueness exists in all constitutional law and has been applied with special rigor in the First Amendment, and should likewise be applied strongly in the Second Amendment. In fact, the reason for doing so is even stronger. Bookstores, thank God, are not federally regulated. You don't need a license to operate a bookstore. You may need a general license in the sense that you need a license to operate any business, but you certainly don't have to go through special bookstore licensing. But you do if you're a firearms dealer. You must have a federal firearms license. And small violations of the law can and do sometimes lead to the revocation of that license. Likewise, the harm of vagueness in a gun context is significantly worse, to the extent that it chills conduct and prevents exercise of the constitutional activity. If a law against obscenity, for example, is vague, then one of the harms is that even though obscene material is outside the First Amendment, there may be books that are inside the First Amendment, or magazines or movies or whatever, that a store would be afraid to own, or a person might be afraid to sell, or a person might be afraid to possess. And that is a significant constitutional harm, that the person loses the intellectual enjoyment and pleasure of being able to read those protected materials. It's far more harmful in a Second Amendment context because gun types are not fungible. Different guns are best suited for different people for self-defense, and it's a very individual, personalized decision that depends on many, many variables. So if you outlaw guns in a vague way, like the laws of New York and Connecticut have done, and you thereby make firearms dealers afraid to sell and firearms owners afraid to possess other types of guns because you don't really know the definition, then you may have taken away from someone the firearm that was really the best and most appropriate and most life-saving arm that they could have possessed. Finally, I want to highlight one important difference between the First and Second Amendments, and that is on prior restraints. prior restraints obviously are presumptively unconstitutional under the First Amendment, allowed in certain extraordinary circumstances, such as the publication of troop movements during time of war, but they are generally not well liked in the First Amendment. In contrast, we clearly allow prior restraints in the Second Amendment. First of all, as I said, nobody needs a license to run a newspaper or open a bookstore, but you do need a federal firearms license to run a gun store. And there's no plausible chance of a winning legal claim against gun store licensing based on the allegation that it's an unconstitutional prior restraint, although it certainly is a prior restraint. And likewise, everyone is in agreement that at least some people who have shown their irresponsibility with firearms, like let's say the guy who was just gotten out of jail for using a firearm in a string of liquor store robberies, that at the very least, some people can be prohibited for at least a period of time from possessing firearms. And that too is a prior restraint. So what I suggest, the lesson from the First Amendment on prior restraints, is to go back to some of the rules that the Supreme Court has set on prior restraints, which again is they may be permissible under certain circumstances. And some of this comes from upholding Maryland's pre-review licensing, pre-review censorship board to protect people from obscene movies in the 1960s, which the Warren Court upheld. Three principles come out of this. First of all, the burden of proof is on the censor. So you can't deny somebody, by analogy, you can't deny somebody the right to exercise their Second Amendment rights simply because you don't like them. You have to have solid evidence of why, such as evidence of a criminal conviction. Secondly, while the censorship board was deemed okay, the final decision had to be made by a judge in an adversary proceeding. And the analogy here is maybe does not always require a judge, because while obscenity is necessarily somewhat in the eye of the beholder and is an individualized decision, most disqualifying factors for gun ownership or for running a gun store are based on fairly objective, indisputable criteria, such as the existence of a criminal conviction. But in the borderline cases, judicial review would be necessary. And then the third requirement from the Maryland v. Friedman case was that the prior restraint has to, and final resolution of this, has to be done within the shortest fixed period compatible with sound judicial resolution. Which means in the context of a film in 1965, when video cassettes and DVDs and all that hadn't been invented, if the film misses its theatrical release in Maryland because the censorship board and the judge are just jerking around and, stopping work at 4 o'clock every day, and they never, the film may only have a 2 or 3 week window when it's being shown in theaters in an economically viable way as part of its national release, and then if you don't get it into the theaters then nobody can see the movie, which is a serious harm, although it's a harm that, at least from the film producer's point of view, is fully redressable after the fact by economic damages. It's much more serious in the case of the Second Amendment when you have a prior restraint that goes on too long. Bonnie El-Masri in Wisconsin was being stalked, and so she went to a store to buy a handgun, but she couldn't take it home with her that day because Wisconsin had a waiting period of days before you could take the gun home back then. No, I believe that's been repealed in Wisconsin. And because she couldn't, although she was a lawful gun purchaser, she wasn't allowed to take her gun home, she was murdered in the meantime by that stalker. In California today, there is a 10-day waiting period for the purchase of guns between the time you walk in the store and you pay for it versus the time you are allowed to pick it up. that is being challenged in a lawsuit, and the court there rejected the California Attorney General's motion for summary judgment on the issue, because it was indisputable that the background check requirement was fine, that's okay. But today, you don't need 10 days to do a background check. It's done in a matter of seconds, with the firearms dealer sending in over the computer biographical information to the state's background check unit, and the process of, okay, here's the name, here's the date of birth. We run the person's name against our various databases of prohibited persons. Does the person show up in any of these prohibited databases? No. Go ahead and do the sale. And you will sometimes have a case where, for example, there's a record of an arrest but not of a conviction, and sorting that out might take some time. But in 95% plus of the time, there is no need at all for the 10-day sale, and that is an unconstitutional prior restraint. Thank you.